All right, I'm going to go ahead and kick it off.
Yep, go ahead.
All right. Good afternoon, everyone. Good afternoon. It's a pleasure to see you all. For the few of you who I don't know, I should introduce myself. I'm William Carter. I have the pleasure and privilege of being the Dean of the University of Pittsburgh School of Law. And I also have the distinct honor of welcoming you all to this year's Lawyering for Social Change lecture titled Color-Coded Justice, the Legal Battle to End Stop and Frisk in New York City. In just a moment, I will introduce Professor Lobel to let him do the formal introduction of our speaker. But again, I wanted to just welcome you to this series. Mr. Warren is the latest in a very distinguished line of speakers for this lecture. It's one of the highlights of the year here at the law school. And this one is on a particularly interesting and timely subject that I'm sure you'll enjoy learning more about, both from Mr. Warren as well as our distinguished colleagues here who have done quite a bit of work, both scholarly and litigation in this subject area. So with that, this is probably the briefest set of remarks you will ever hear from a dean, because I'm going to get out of the way and I want to hear our speaker. But before that, let me just introduce Professor Jules Lobel, one of our most distinguished faculty members, the holder of a distinguished chair, someone whose work in the field of civil rights and human rights is without peer in the legal community. It's really a pleasure to have gotten to know Jules as my colleague and friend in my relatively brief time here. So with that, I will get out of the way and give you Professor Lobel for the formal introduction. Thanks again for coming.
Thank you, Dean Carter. It's my great pleasure to introduce my friend Vince Warren, who is the Executive Director of the Center for Constitutional Rights, which is a national legal and educational organization dedicated to advancing and defending the rights guaranteed by the U.S. Constitution and the Universal Declaration of Human Rights. Vince oversees the CCR's groundbreaking litigation and advocacy work, which includes using international and domestic law to hold corporations and government officials accountable for human rights abuses, challenging racial, gender, and LGBT injustice, and combating the illegal expansion of U.S. presidential power and such policies as the illegal detentions at Guantanamo Bay. In connection with the work at Guantanamo Bay, Vince was one of the few people invited to the White House to confer with President Obama after Obama got elected, within several months after he got elected. And it's really telling about Vince what happened at that meeting, because at that meeting the president is sitting there, and I would think that I and many other people in that situation would be quite deferential. Vince is not deferential. One of his great features, both as an executive director and as an advocate and as a litigator, is that he doesn't give in when confronted by injustice. And when President Obama said to Vince Warren what he thought, asked him what he thought, he said, "Your legacy will be defined by what you do with respect to Guantanamo." An answer Obama did not want to hear. Prior to his tenure at CCR, Vince was the national senior staff attorney at the American Civil Liberties Union, where he litigated civil rights cases, particularly focusing on affirmative action. And Vince tells me that he was the ACLU point person in the Michigan case, which many of you have studied in constitutional law and affirmative action, Gratz v. Bollinger. Prior to the ACLU, Warren monitored South Africa's Historic Truth and Reconciliation Commission hearings and worked as a criminal defense attorney for Legal Aid Society in Brooklyn. He's a graduate of Rutgers Law School, and I know that several years ago he was invited back to Rutgers, this time to give the graduation speech to the graduates of Rutgers. So those of you who are sitting in the audience who are students, this is what you should aspire to. That at some point later in your career, you'll be invited back here to give the graduation speech. Today, Vince is going to be talking about the stop and frisk litigation, which was a historic victory that the Center for Constitutional Rights won in New York City, challenging the New York City Police Department's policies on stop and frisk, a case which is defined both by its brilliant legal theories and by its persistence. This case has been going on for over a decade in one form or another, and finally has resulted in a historic transformation, or hope for transformation, in the New York City Police Department. So without further ado, Vince Warren.
Thank you, Jules, and thank you, Dean Carter, for the wonderful introduction. Thank you, Professor Harris, for being here, and thank you all for coming to listen to me talk a little bit about some of the stop and frisk work. I will say that having been a lawyer now for 20 years, I remember very much when I was sitting in seats like the ones that you're sitting in. And I think in addition to hearing about the work that's happening, at least at the time, I was always interested in how people actually got to where they were, some of the folks that I was thinking about. So what I will just try to do at the end of this piece, as part of the social change aspect, just to talk a little bit about my trajectory, how I got here, and how I was fortunate enough to be able to do some of this work. But let's talk stop and frisk for now. The stop and frisk case that many of you have heard about, some of you have read about, didn't start in August of 2013, and it didn't end in August of 2013. That was the point at which we've got a tremendous ruling from the district court judge in the Southern District of New York as a result of a 9.5-week trial. But where actually stop and frisk started for the Center for Constitutional Rights was back in 1999. In New York City in 1999, there was a different police commissioner, there was a different mayor, and we were coming off of a decade of record crime in New York City, which happened to be going down right around that time. And the New York City Police Department had a very aggressive policy with respect to street crime, and they had a unit that was called the Street Crimes Unit. And this was a hand-picked set of police officers that operated very much like a SWAT team. They were not assigned to the usual precincts. They actually had an office that was in a place called Randall's Island, which now where my kids play soccer, coincidentally enough, but it was far away from where the normal police departments were. And this was an elite unit, and what their job was to get guns, particularly guns, off the street. And so in 1999, they came across in the Bronx a young man by the name of Amadou Diallo. And Amadou Diallo was a young African immigrant. And he was poking his head out of, it was a cold day, he was poking his head out from his doorway, looking around, and the unmarked police car came up, saw him, and thought there must be something going on. So they came out with their guns drawn, and they told him to get on the ground, and they were yelling and screaming. And Amadou Diallo did one of the worst things you can do as an African-American man being confronted by the police. He did this. He reached into his pocket for his wallet. The police said that they mistook that for a gun, and they shot him 41 times and killed him. Why that has to do with stop and frisk has more to do with the community reaction to that police shooting. Communities react very viscerally when they feel like their children, with the young folks in that community, are at the whim of random police violence. When the code of connection between how police are supposed to be policing with the community shifts to how the police are policing communities, and particularly when there are terrible things that happen, people get very upset about it and they rise up. And there was a broad movement in New York City around police shooting and police violence. So in 1999, the Center for Constitutional Rights filed a case called Daniels versus City of New York. And that case challenged, of course, that shooting, but it also challenged the way that that street crimes unit was interacting with citizens. It alleged that the street crimes unit was operating not in compliance with the Fourth Amendment or the 14th Amendment. That case settled in 2003, and the New York City Police Department said that they were going to do three things as a condition of that settlement. Number one, that they were going to create a policy that prohibited racial profiling in New York City, which most people would think is a good thing. The other thing that they said that they were going to do, because we pushed for it, was in order to comply and monitor the decline in stop and frisks pursuant to that policy, that they were going to continue to give the Center for Constitutional Rights, who were plaintiffs in the case, the police data on stop and frisk so that we could monitor it. And the third thing that they said that they were going to do was that they were going to establish internal controls within the police department to ensure that stop and frisks and this unconstitutional policy didn't happen again. And those all seem like very great things, but only one of them ended up being the piece that actually changed the way the police department worked. And that one thing of those three main issues was the fact that they continued to give the Center for Constitutional Rights the police data. Because what we found was after 2003, that stop and frisk didn't go down. It didn't even go down a little bit. It went up, and it went up about 600%. The number of stops in New York City went up after the city said that they were going to settle between 2003 and 2012, 600%. And what does that mean? That means that around 2003, the police department was stopping roughly 200,000 people. It's a lot of folks, but New York City is a big place. And it began to increase, and they were steadily stopping 400,000, 500,000, to a high of 680,000 people in New York City in 2011. And to give you a sense of how many people that is, if you imagine Heinz Field, if the police went to Heinz Field and stopped every single person at every single home game at Heinz Field, that's still not the number of people that they stopped in 2011, 2012, or 2010. So we filed a new case in 2008 based on that information. And the new case was called Floyd versus City of New York. And the Floyd case actually had two main points. One is that we were alleging that there was a practice and a policy of racially based police stops, that were police stops that were not based on any reasonable suspicion, but were based primarily on race. There was a 14th Amendment allegation that the stops were unrelated to Terry versus Ohio, and there was the 14th Amendment allegation that this police department deliberately was stopping more black people than white people. And we filed that case under a Monell theory, which is based on Monell versus City of New York, which allows plaintiffs to get to municipal liability. As you know, that the Fourth and 14th Amendment generally apply to state action. Monell is an opportunity to get to municipal action. The New York City Police Department is a part of New York City, so the case is titled Floyd versus City of New York. Now, on the fourth, the other thing that's important about this case is that it wasn't just on behalf of 1, 2, 3, or 10 individuals. We actually had a class action. So this was on behalf of everybody who was stopped pursuant to the policy between 2005 and 2011 or 12. And so that was roughly 4.5 million people that were a member of this class. So let me talk about the Fourth Amendment violation for a second. You all have read Terry versus Ohio, and that you know that the police department police officers can stop people in street stops for particular reasons, right? They can stop people if there's indicia of a crime happening. They can stop people based on reasonable and articulable suspicion about what's going on. But we also know that they can't stop people based on a hunch. They can't stop people based on generalized information about crime in a particular neighborhood, and they can't stop people for a discriminatory reason. So we looked at the data and the information from the stops that were happening, and we found very interesting things. Number one, in addition to the massive number of people that were being stopped, that in and of itself isn't anything but a bad policy decision. But we found that in all of those stops, that we were beginning to see that there was no credible, reasonable, articulable suspicion for stopping all of these people. And looking at, remember I told you that the really key piece was that the New York City Police Department agreed to give us the data on the stop and frisks. Here's what the data was. Every time that the police department stops someone, a police officer stops someone, they have to fill out what's called a UF-250 form, which is a stop and frisk form, and they fill it out when they get back to the precinct. It's got the name, it's got the address, where the stop happened, what the circumstances were under the stops, the reason for the stops, the race of the person. We took all of that data for millions and millions of stops. We converted that into spreadsheets. This is, of course, where my knowledge begins to fade. I'm good on paper, but I'm terrible as soon as you put me in an Excel spreadsheet. But we did have people that knew what that data was, and we began to crunch it. And beginning to look at that data in the aggregate, we began to see some really interesting things. One of the things that we saw was that the reasons that the police officers were giving for stopping people were not what you would necessarily think. It wasn't because we thought that we had information that this person had just committed a crime or was just about to commit a crime or was committing one right there. 55% of these stops, that the reason the police officers gave in their memo books was because the person was moving furtively. I know you guys need to Google furtive movements if you don't know what it is. The best example of what a furtive movement from my perspective would be Marco Rubio trying to drink a glass of water during the State of the Union address. Did you guys see that? It kind of looked like this. Right? This is a furtive movement, right? A furtive movement is when you're looking around like you've done something wrong. So now we have to think about 55% of 600,000 stops in a particular year. What does it look like to have 300,000 people walking around looking furtively? That doesn't make any sense at all. It can't possibly be that most of these stops were because of furtive movements. Then the second biggest reason that they gave was because the perpetrator fit the description. This is where we get kind of interesting, and we see that there's an interplay between the Fourth Amendment analysis, which is a pure search and seizure analysis, and the 14th Amendment analysis, which of course brings in race. So what happens is they say that the person fit the description in their memo books, and that assumes two things. It assumes, number one, that someone had called in to the police department a particular crime, and number two, that they gave pedigree information, race, height, clothing of what the perpetrator looked like. And that information was transmitted to the police officer. The police officer then saw somebody that fit that description and stopped them, right? Those are the steps that are in play that necessarily have to be in play in order for somebody to fit the description. What we found that there was such a high percentage of people that supposedly fit the description, we began to ask ourselves, well, let's begin to play out and let's begin to look at, are there actually these types of radio calls? Are there actually these kinds of things coming from the community that would form the basis of a description? Because on its own, saying that every black person fits the description of a perpetrator in order to justify a stop doesn't really make a lot of sense to us. Which brings us to the 14th Amendment argument. 87% of the people that they stopped over this period of time, 87% black and Latino. That's not shocking to some people, but it's shocking to me, particularly in light of the fact that when you look at the massive number of stops, the massive number of those stops that are people of color, black and Latino, the relatively small percentage of black and Latino people in the community, which is roughly 26%, and then also the relatively small hit rate. By hit rate, what I mean is that if they're supposed to be getting guns off the street, then you would think that a larger percentage of the guns that they're going to get off the street would be off of black people, since they're stopping so many. And you would also think that given so many stops, that the relative hit rate would be fairly high. And we found out that neither one of those things were true. In terms of dispositions, right, so the people that they stopped, they only referred 6% of the people that they stopped to courts for summonses. So these would be low-level offenses, things like drinking in public, or low-level marijuana arrests. And then they referred another 6% for arrests. And let's assume that those are kind of more serious crimes. But that's essentially a 12% success rate for a stop and frisk program that stops over 500,000 people every single day. That we, of course, were alleging was racially discriminatory. So the idea that the policy was a good crime-fighting tool was, I think, belied by their own statistics, that a relatively small percentage of the people that they stopped were actually referred to any criminal court activity whatsoever. And then when you looked at race, you began to see that black people were actually less likely than white people in looking at the statistics to have a gun charge or to have a a drug charge come out of these stops. If you look at white folks alone, white folks were actually, a higher percentage of white folks than black folks were found with drugs on them in this big sweep, even though 87% of the people that they were stopping were black and Latino. So what we were able to find from the data was that the program certainly didn't work. The program certainly looked like it was discriminatory if you just look at who they got drugs and guns from, and that it was a bad policy decision and it should stop. But we went a little bit further with it. And we also have this challenge, right? We all have this challenge under the 14th Amendment, which is it's one thing to allege something, and it's one thing to have data that points out what the problems are in the policy. But as we know that on the 14th Amendment analysis, you can't prove racial discrimination just based on data alone. You need to have some level of intent. That the disparate impact theory doesn't really work anymore, so we had to convince the judge that there was actually a policy and practice of intentional discrimination with respect, or something approaching intentional discrimination with respect to the stop and frisk policy. So what we found was when we did a regression analysis with our experts, and we began to look at, are there other reasons why we would have a racial disparity like this in a stop and frisk policy? And we know that from the 14th Amendment analysis that whenever the plaintiffs allege a discriminatory action, that the defendants have to show a compelling interest in why that action should maintain even though it is discriminatory. So that they had a relatively high burden of showing what their compelling interest was. And they essentially said, the police department said they had two main things. Number one, they had a compelling interest to stop crime and to get guns off the street. They also said they had a compelling interest in keeping communities safe, particularly when they found that a large percentage of the calls that they got from community members and people in the community had a black or Latino perpetrator as the alleged perpetrator. So their argument was really they argued in the alternative. Number one, they said, we're not discriminating because we are going after guns and drugs, and that people are telling us that the people that have the guns and drugs are black folks. And on the other hand, they're saying even if we are discriminating, it's okay constitutionally because the public safety issue is so great that should be an effective counterbalance. So when we looked at the regression analysis, we found the following thing. We found that thinking about drugs and guns and crime and community safety and all of those other things, when you began to control for those factors, all of the factors that were there, race was still the predominant reason why people were stopped. What I mean by that is, if you look in a low-crime neighborhood, crime doesn't happen that often in a low-crime neighborhood, so presumably the policing in a low-crime neighborhood would be different than in a high-crime neighborhood, different resources that are spent towards that. But we found in low-crime neighborhoods, blacks were stopped more often than whites. And then we looked at medium-crime neighborhoods, and we found that blacks were stopped more often than whites. And we looked at high-crime neighborhoods, and we found that blacks were stopped more often than whites. And then we started to think, well, maybe it's the neighborhood composition. So let's start looking at the racial makeup of neighborhoods, because, of course, the police department was saying, well, in black neighborhoods, of course there are going to be more black people that are stopped than white people. In Latino neighborhoods, of course there are going to be more Latino people stopped. And it was true in black and Latino neighborhoods where it was racially segregated, blacks were stopped more often than whites. But blacks were stopped more often than whites in mixed neighborhoods, and blacks were stopped more often than whites in white neighborhoods. There was literally no scenario in New York City in which blacks were not stopped more than whites. And this is what the data was showing with respect to this case. So then we have this other problem. How do we prove this beyond just what the data shows, right? How do we prove that there is actually a clear, distinct policy to stop black and Latino people, not because it's related to crime, but because it is essentially discriminatory? And we got a tremendous amount of help from the police department themselves on this, and in two really kind of key ways. Number one was each one of our main plaintiffs, and I think we had 19 of them in all, gave very interesting and compelling testimony about how they were stopped. And so part of the analysis was what was the police interaction and what was the reason for the police department stopping these particular representative plaintiffs. And then we also had some information from the police departments themselves. So starting with our plaintiffs, I'll just give you one example that relates to the analysis of crime in the neighborhoods and fits in the descriptions. Our main plaintiff was a man by the name of David Floyd. And David Floyd, not a drug dealer, his family actually owns a brownstone apartment in Brooklyn. And David's was in the upstairs apartment in his house, and they had a downstairs tenant that lived in the basement. The downstairs tenant had locked himself out of his apartment, and he went to David. He called him up on the cell phone. "Hi, I locked myself out. Can you just bring down the spare key and let me back in?" David came downstairs and walked along to the side of the house. David had a big key ring, which his mother had all of the keys on, and so they were on the side of the house looking to try to fit the right key into the downstairs apartment so that they could get in. And of course, that was when the police department police officers came up, and what they saw was two black men trying keys in the side of a house in Brooklyn. What they assumed was that these are two people that are trying to break into the apartment. So of course, they came out, they put everybody against the wall, search, stop, frisk, rough manhandling and that type of thing. David's trying to explain what's happening. They're not trying to hear it. They ended up not getting arrested, but it was a very, very horrible experience for David and for this man. And let me just sort of take a moment just to talk about impact, because it's very important for law students to remember that there are human impacts to everything that we are studying and everything that we're learning. There is a human impact to the Fourth Amendment. There is a human impact to the 14th Amendment. And the human impact on stop and frisk is that that type of stop, if it has ever happened to you, regardless of your race or gender, you know it is a very scary thing. That you really start thinking, what is going to happen to me next? I can't reach for my cell phone and call somebody because that's going to be seen as a sign of aggression. I can't stop them from doing the thing that they're going to be doing because that's going to be seen as a sign of aggression. All I can do is comply and hope for the best. And that is a very debilitating position for anybody to be in, much less people that are not doing anything wrong. So when we talk about 5 million stops, you need to think about that experiencing happening 5 million times. You need to think about that happening 600,000 times a year, because that's how people are feeling this type of situation. So getting back to David Floyd, so that was the evidence that was presented at trial about his experience. The police officers then, we called them as witnesses, and the police officers said, well, the reason why we actually stopped him was because, yes, we did think that he was trying to break into an apartment. We didn't know that it was his house. But we were responding to the fact that there had been a series of burglaries of that type in that neighborhood that had been reported. So it wasn't that we saw just black folks doing it, it was that we saw people doing it, and we were armed with this information from the precinct that there had been a series of similar burglaries, and we were trying to check that out. Now that makes sense to people, right? That's what police departments should be doing. But you have to ask this question before we get to the answer. That if you have a police department or any government entity, just think about the government entity of choice, if they do not feel that there is any way for them to be held accountable for what they say and what they do, what is the likelihood that they will stretch the truth, that they will straight up lie, that they will fabricate information if they don't really feel that they're going to be held accountable? It's like sort of the meta question is to you, would you lie if you knew that you could get away with it and there would be no repercussions? As individuals, we might have different answers to that, but when you think about it as a system, a police or a military system, there is a tremendous incentive to lie and say things that are not true if you are assured that no one will be able to check behind you and find out whether you're telling the truth or not, right? So the idea is, and you find this, I was a criminal defense attorney for a number of years, that very often police officers on the stand will say all kinds of crazy things, not because it makes sense, but because they actually know that no one will be able to check behind them to see whether what they're saying is true or not. So they learn how to say certain things in order to get back past constitutional problems in court. And that's what these police officers did. Well, we had the data, and we also looked at the census tract information, meaning that we were able to look at each neighborhood and the crime rates in each neighborhood. We were looking at the police calls from each neighborhood, and we found out that although those police officers said that there had been a spate of crimes burglaries in that particular neighborhoods, our analysis showed that there had not been not one burglary call, not one complaint about a burglary in that neighborhood for the preceding 4 months. Now, the reason why we knew this is we were able to pull together all of this information. So what does that tell us? What does that tell us about that particular interaction? Number one, that there was no burglary call. There was nothing from the precinct that said the reason why you need to stop these men is because they might be committing a burglary, which is a problem in the neighborhood. And we were reduced back to the idea that there are 2 black men trying to get into the apartment. So that's part of the analysis and the depth of the analysis that we were able to do in some of this litigation. I want to just give you another piece of information that is really kind of more like the smoking gun stuff. Again, well, for those of you who don't know, the New York City Police Department is the largest police department in America. It is regarded sometime as the 7th largest army in the world. At some point, there were 44,000 police officers. I think there are less now. But what they have done for many, many years, even going back to 1999 with Amadou Diallo and going back well back into the 1960s, is that they've created an entity called the Blue Wall of Silence. And what the Blue Wall of Silence is a credo and creed that no police officer shall ever rat on another police officer. What we do behind the blue wall is our business. All people need to know is that we're keeping people safe. And there is that blue wall of silence. People have gone to jail for not ratting on their other police officers, and that is something that was alive and well. Well, what we had in the case was we had a piercing, a slight view through that blue wall of silence in the litigation. After we filed the lawsuit, there were some police officers who were actually mostly black and Latino, although not all, that began to be troubled by the policies of quotas for stop and frisk. There was a police quota. You had to come up with a certain number of stop and frisks. It didn't matter what the people were doing, it didn't matter what the people looked like, but you had to get the numbers, and people were being judged, police officers were being judged by their stop and frisk quotas. The police department brass said that is an absolute fabrication. There is no such thing as a quota for stop and frisks. And it was very hard for plaintiffs' lawyers to be able to prove that. But what happened was that some of the police officers were really morally deeply troubled by what they saw as a conflict between their role as a police officer, as working with communities, and the way that this quota was operating, which was making them essentially policing the communities themselves. So they began to tape record surreptitiously some of the meetings in the precinct where they were talking about some of these issues. And there were 2 that came that were kind of smoking guns on this issue. Number 1 was in a precinct in Brooklyn. The desk sergeant was doing roll call, and this was recorded, and that the desk sergeant kept saying to the police officers, there was a particular subway stop that around 3:30, I need stop and frisks in that subway stop at 3:30 every day moving forward. Now, when you look at that subway stop, it was near it was in a predominantly black neighborhood, predominantly black school, and essentially the sergeant was saying you need to stop these high school and junior high school kids and stop and frisk them when they come out of that subway stop, right? So Fourth Amendment analysis, it is impossible to comply with the Fourth Amendment if you are telling people to stop a range of folks because of race or because of location. 14th Amendment analysis, that it is likely that it is based on some level of racial animus if the people that you're targeting without any suspicion whatsoever are black and Latino. So that information and those tapes were played at the trial. There was another one from the 41st Precinct in the Bronx, which was very telling, where a Latino officer taped his precinct commander. And they got into this really interesting discussion where the precinct commander was saying, you're not stopping enough people. You need to stop the right people. And the officer says, well, who are the right people? And the precinct commander says, I'm not going to go through this again. We've been through this. I'm not talking about, this is what the commander says, I'm not talking about the grandmothers in Central Park. I'm not talking about those people. You need to stop the right people. And after pushing, the precinct commander said the following things. You know what I'm talking about. I'm talking about black males aged 14 to 20 or 21. That's who I'm talking about. What does that mean for us? That is a smoking gun of relating to two things. Number one, it is primarily race-driven as to why these stops need to happen. It is driven pursuant to a quota, which also means that it can't possibly be connected to reasonable suspicion or the game time decision on the streets. So we began to fold all of that information into our analysis so that the information that we presented to the court was a combination of police officer testimony, being able to debunk some of the standard police officer sort of canned testimony by looking at the actual facts that the police department were producing, and being able to talk about our client's experience and the experience of a range of other folks. So taking us back to August of 2012, after 9.5 weeks, Judge Shira Shinland issued a 200-page decision that was based on 8,000 pages of testimony declaring quite clearly that the stop and frisk policy violated the 14th and the 4th Amendment of the Constitution, which then moved us to the remedy phase. And the remedy phase was going to be a joint remedial process, because now that we won the constitutional battle, the hard part really begins, which is how do you begin to change police practices? I was talking to Connie Rice not too long ago, who's out in LA, who had worked with the Los Angeles Police Department. And Connie Rice said, you can put on the piece of paper all of the changes that you want, but what you need to do is you need to change hearts and minds within the police department, and you have to change hearts and minds within the community, and that is a very long, hard process. And so that was the process that we were about to embark on. The New York City Police Department appealed Judge Shinland's decision. It went before the Second Circuit Court of Appeals. There were two issues in the appeal. One was that the city wanted to stay the remedial plan in order to determine whether the merits appeal, whether Judge Shinland was correct or not, right? So there was a stay, which means don't move forward on the remedial plan because it's going to cost us money and it's not going to be fair if Judge Shinland was wrong. And then there's the merits opinion, the merits appeal, which they were saying Judge Shinland was wrong. She got the whole thing wrong. So the Second Circuit had both of those issues and an argument for the stay. Again, the only thing that we're arguing is should we move forward with this remedial process before the court decides whether Judge Shinland was right. The Second Circuit did a crazy thing that I've actually never seen happen before. The Second Circuit, of course, they denied our position was that there shouldn't be a stay and we should move forward. They said, no, we're going to put in the stay. But they also did something else, which I've never seen, which is they said, you know, Judge Shinland spoke a lot about this case in the public, and when you shifted from going from the Daniels case to the Floyd case, she accepted the Floyd case as a related case under the rules, and we think that was a violation, and we also think that she spoke to the media too much. So Judge Shinland is now removed from your case. We went to the Court of Appeals to determine how we were going to move forward, and the Court of Appeals removed Judge Shinland from our case. I will say, just for brevity's sake, it was preposterous that Judge Shinland did anything wrong. Under any reasonable analysis, she most certainly did not. But what was really interesting was that no party before the court that day had raised or had ever raised the issue that Judge Shinland had done something unfair. The court did that sua sponte. And we would have to ask yourself, why would the court feel so compelled to literally pull out its own evidence and cite various newspaper articles and things like that, and then yank a judge from the case? The answer to that is, I think about it in the following way. There's a great phrase that has been attributed to Martin Luther King, which says that the arc of justice is long. It's a long one, but it bends towards freedom. And I do think that that's true. But part of the reason why the arc of justice is so damn long sometimes is because when you make a big change in the power structure, we literally were able to completely debunk an entire 20-year period of stop and frisk in the New York City Police Department. That what ended up happening was that the power structure, the courts, the city of New York, some of the media, began to become very uncomfortable with that level of change that had happened through the court, and there was a big pushback. And the pushback was, I think, quite naked and a little bit disappointing that an appeals court would essentially abandon the long-held principles of how they think about cases in order to try to yank that victory out by punishing the judge. They couldn't punish us because we won the case, but they ended up punishing the judge. Long story short, we are now back on track. Unfortunately, Judge Shinlin is not on the case anymore, but there is a new judge, Judge Torres, who is on the case. We have had a change in mayors. We have a new mayor, Bill de Blasio, who has taken a very different position from the old administration. He has agreed to drop the city's appeal and to begin to move forward with the reforms. So over the next several years, we're going to be looking to build in a community reform model, which we call the joint remedial process, that doesn't just have the lawyers sitting at the table arguing and throwing paper at each other, but actually builds in a community context. So at the table will be the religious communities, the grassroots organizations, affected members of the community, the police union, the police department, the mayor, and a whole range of other folks, not so much to fight over what is going to happen in this piece of paper, but really to sort of do that thing that Connie Rice was suggesting that we think about, which is how do we actually change hearts and minds, both in the police department and in the community, so that we can shift back to a place, or shift to a place, an experiment in New York City, perhaps for the first time in history, about what a community-based policing model might look like in New York City. Thank you very much for listening to me.
I'm going to introduce Dave. We're very fortunate today that not only do we have Vince Warren speaking on this issue, but we have one of the nation's leading experts on this issue and on the whole issue of racial profiling in police departments' work on this faculty, and that's David Harris, and he has graciously agreed to comment for 10 minutes or so on Vince Warren's talk. David.
Thank you so much. Thanks very much to Professor Lobel for extending the invitation to Vince Warren, bring him here. It's an extraordinary treat and a pleasure for us in this building to be able to hear from people who have reached the kind of professional peak that he has in so young a man, and who has participated in real change. Thus, why he is such a good candidate for this particular lecture. I'm just going to talk for a few minutes because I know you must have a ton of questions for him. I want to just add a few things to the picture to broaden things out a little bit, because I think that the Floyd case, what it has done, what it will do, will be one of the landmarks of the early 21st century as far as policing, as far as the relationship between police and the people they serve. Point number one, let me start here. One of the things that Vince said was that one of the prime objectives of the stop and frisk program since the Giuliani years has always been getting guns off the street and fighting crime, but more more particularly getting guns off the street. I mean, you could see this in written policies, in statements by Giuliani, by Bloomberg, by Kelly, by one of Giuliani's many commissioners of police for a long, long time. When they crunched the data at CCR and looked at how effective this program was at getting guns off the street, as Vince said, it was not very effective. But let me just put a number on this and make sure I get it right. It was less than 1% of all stops turned up a gun. It was a lot less than 1%. What was it? 0.1? 0.014. All right? That's the degree of effectiveness that we're talking about. Now, that doesn't seem like it should justify the stopping of hundreds of thousands of people if that's all you're doing. I have had the opportunity in a number of different situations to, let's just say discuss would be a good word for it, discuss this very number and result with members of the New York City Police Department, both former and current. So I've put it to them, how can you, what do you think about this 0.01 whatever? And what they say is, success, it works. And I say, what? How does, it works? It doesn't seem like it works to me. Can you please help me understand? They say, well, you see, the results may look very low to you, but what that means is that it's working because people are afraid to carry their guns on the street. And so it's working. Thus the comment by, I forget if it was Mayor Bloomberg or Kelly, Commissioner Kelly, or both, in the run-up to the verdict in which one of them said, if it were up to me, I would do more stops of young black men because I want them to be afraid. Their words, not mine, only slightly paraphrased. So you have this odd situation, which always reminded me of this game, if you want to call it that one of my uncles used to play with me when I was a kid. He'd come up to me and he'd say, hey, let's play a game. Let's flip this coin. If you can guess which way the coin is going to come up, you get the coin. You get the quarter or the $50, whatever it was. I'd say, okay, great. My little 5-year-old self, and he'd say, here's the deal. Heads, I win. Tails, you lose. Okay? That's what this is. Because if you say, if the police department was raking in guns, that'd be a big success. If the police department is not raking in guns, guess what? That's a big success. How do you argue against that? Right? You've got it both ways. So this is something I think that gets comparatively little attention, but that the litigation with CCR in the court brought out brilliantly. Point number 2, in the run-up to the litigation, and during the trial and after the trial itself, which was a bench trial, was over, and between the end of the trial and the rendering of Judge Schindlin's opinion, there was a storm of media attention, or maybe it's better put, a storm of comment by Mayor Bloomberg, Commissioner Kelly, and other city officials about what would happen if the judge made the mistake of finding for the plaintiffs. And they said most emphatically, over and over, in any way that you could imagine, that if Judge Schindlin ordered an end to the current stop and frisk policy, or ordered some change in it, that this would cause crime to shoot up through the roof, that we'd be back to the bad old days and the chaos of crack-ridden New York in the 1980s and the burning Bronx and all that stuff, that the stop and frisk policy by itself was responsible for a huge reduction in murders. They claimed the reduction in murders over the time, that the murders that would have been there with the late 80s, early 90s rate of crime, they claimed that those that had not happened were the direct result of intense stop and frisk activity by the NYPD. A couple of things I want to say about that. Nothing when you discuss crime, nothing in the discussion of crime is 100% clear. Frank Zimmering, who is one of the most eminent criminology law professor people, been out at Berkeley for a long time, he has a way of putting this. The dirty little secret when we study crime is that nobody actually knows what makes it go up and what makes it go down. You know, he has also added that some of the things that you do in policing, now we know after the 90s, some of the things that police departments started to do, and started to do in New York, I might add, do have an effect on crime. Police can have an effect. But to say that any one thing could be responsible for all of that reduction and all of that preservation in life is just foolhardy. And more than that, it ignores some of the other good things that the NYPD did in the same period of time. And it ignores the fact that crime was actually going down before the NYPD's intense stop and frisk policies came online. And it ignores the fact that many other cities had comparable drops in crime over the same period of time using very different strategies and tactics. All right? So there's more than one way to skin a cat. The idea that it's just this and this only, that was part of that naked pushback that Vince was talking about. It was in the media, it was everywhere. And just so we have the record straight, maybe it was coincidence, maybe not, but a little bit before the trial started and it became clear that there was actually going to be a trial, the NYPD started to do something unexpected. It started to back off of stop and frisks. What do you know? I guess it's just a coincidence. But stops and frisks began to go down in 2012, measurably, markedly. And they are still going down now. And guess what? Crime did not go through the roof. Murders did not go through the roof. The sky did not fall. In fact, crime kept going down. All right? So, for Mayor Bloomberg, former Mayor Bloomberg, who was such a data person, built his fortune on financial data, I think maybe you ought to study the data just a little bit. Last comment I'll make here is you now know what happened in the Floyd case and you're up to date. What I think you should anticipate, what could happen, is almost just as interesting because the NYPD is a tremendously not only large but influential organization in American policing. It's for a reason that a lot of those cop shows, they're not called Pittsburgh Blue or Chicago this or that. Some of them are, you know, but it's New York. It's the media capital of the universe, and what happens in that police department, for good or for ill, will have profound ripple effects across American policing. So to the extent we now have a real honest-to-God reform effort about to take shape and move forward, to the extent that we get a different variety of policing in the United States from this point, one that respects the relationship that any good police department has to have with the people that it serves, that will have started with Floyd, and it will make a huge difference in this country. I can't say with certainty that that's what will happen. We all know how things change and mutate and sometimes don't work out the way they want, the way that we want, but I am optimistic for the first time in a long time that we're going to see some very positive change, and it's going to start in New York. Thank you for your time.
I'm wondering if there are any questions.
We have about a half hour, 25 minutes for questions or so.
Yes.
In regard to the surreptitious tape recording of police officers' conversation, is New York a one-party permission state or a two-party permission state?
New York is a one-party permission state.
In Pennsylvania, we couldn't do that.
Right. Yeah, the question is that in some jurisdictions you need to have both parties have knowledge of a recording conversation in order for it to either be admissible as evidence. In some places you just need to have one party. And New York is one of those strange states where you just need to have one party. So if you are recording something and you know it, the person that you're recording doesn't necessarily have to know it. Hi. Yes, there were a number of, the question is, were the people that were recording, did they remain anonymous, and if not, were there any repercussions? The answer is no, they were not anonymous. That they, one of them gave the whole set of data to a paper called The Village Voice, who then ran a whole series of articles on it, and he was brought to, it was actually, again, very naked and disappointing what the police department did. It was this old tactic of saying that this man, this police officer, has had disability issues and he is now mentally unstable and mentally deranged. So that there was a whole media offensive around this particular police officer, calling into question his emotional and mental health, which is a tactic, of course, that's designed to deter people from coming forward that way, because of course you can't unring the bell because he recorded what he recorded, and regardless of what his mental health status is, it doesn't change what other people said. But that's what happened to him. The second officer in the Bronx was also was public. I think he and I were on a TV show, Melissa Harris Perry, together, and his tape recording happened actually in the context of a disciplinary union discussion, meaning that he had a general question about how this quota policy was going to work, because he really felt that he should not be stopping just random black kids on the street, but he also was being disciplined, or was afraid he was going to be disciplined for not doing it. So what he was trying to do was just to get some straight information down that he was going to have for his own personal backing if it came to a union issue, and that the precinct commander came up with that particular issue. He's told me that since the day that it came out, he has not had certainly not a good night's sleep. He's gotten all of the terrible duties that police officers get. He's gotten yanked off of duties where people can be promoted through the police precinct. He has got other police officers vandalizing his locker. That my recollection is that there were sort of veiled threats made with respect to his family. And it's been a very difficult time. He is still in that precinct, as last I heard, and in fact was really just soldiering on, even though it's become very, very difficult for him. His career is essentially over, which actually reminds me of one particular. Well, I actually won't say that point, but it's been very hard for the people that have come forward, as it usually is with whistleblowers. Any questions from the back? Hi, Brett.
Discriminatory practices against Muslim communities, and I was wondering if you could discuss that case a little bit, what happened in the district court, and how plaintiffs are moving forward.
Okay. I don't have to repeat that question because you all heard it. Yes, we have another lawsuit involving the New York City Police Department, and this case is actually challenging the NYPD's Muslim spying program. They quite literally have mapped Muslim communities in New York State, in New Jersey, and in Connecticut, and that the New York City Police Department has a series of informants and other devices that targets shops, mosques, schools, and various other things in New York City and outside of New York. The ACLU and a range of groups have filed a lawsuit with respect to New York spying. CCR and Muslim advocates in San Francisco have filed a case in New Jersey. The reason why I thought the New Jersey case was an interesting one was because it's the New York City Police Department, right? So I'm thinking, what jurisdiction could they possibly have to be doing any kind of operation in another state, particularly without the other state's approval? And we found that our clients include former veterans, actually active duty members. They were spying on a Muslim girls' school. Young girls that were being trained and learning the Muslim faith. They were spying on that school. They were spying on Rutgers University students. They were spying on black Muslims in Newark. It was a crazy constellation of spying that happened. And of course, as with most of these things, not one single arrest happened, not one bit of information came out, but they were doing this It's primarily a First Amendment challenge. They were doing this basically because people were Muslim. They were just looking at people who were Muslim and spying on them. We filed a lawsuit there. The city moved to dismiss. We had a terrible ruling in the District Court of New Jersey not too long ago, maybe a month and a half ago, where the district court dismissed our case because they found that we had not stated a claim. And it's just actually worth just getting into this just for a little bit, because many of you who have heard about the New York City Police Department spying program, the only reason why you've heard about it was because the Associated Press had broken a series of stories on this over a number of years. They won the Pulitzer Prize for this amazing reporting that they did, and the judge, in his infinite wisdom, said, you know, the harm to the plaintiffs was not actually from the New York City Police Department, because the New York City Police Department, this is gonna like make you guys dizzy, so just, you know, be forewarned. The New York City Police Department spying program was secret. And because it was secret, it could not possibly have harmed the Muslim people that they were spying on. And in fact, the judge goes on in his 10-page opinion, he said that if there was any harm at all, the harm resulted because the Associated Press exposed the secret program. So essentially, that we were just suing the wrong people, right? We should have sued the Associated Press because they were the ones that caused the harm by making the secret program. It's crazy. That's what's sort of been happening in New York, in New Jersey. The New York program is still moving forward. We're going to be appealing the New Jersey case because, as my kids say, that just don't make no kind of sense. So, anybody from the back? I know people in the back have questions. Hi.
Low-level marijuana arrest, because I know the County Bar Association actually had us write, like students applying for a scholarship, write on the quotas for drug arrests and how that was negatively affecting the black community. Could you give a few comments on that?
Sure. The question is, what's the relationship between the drug quotas and the stop and frisk quotas? And the answer is that they are largely connected in interesting ways. I'm not sure that the New York City Police Department has put them together in such a way so that it's intentional, but that's how they play out. The number of marijuana arrests in New York City are enormous. So marijuana stops. People, for a small amount of marijuana, you can get a summons. For larger amounts of marijuana, it can be either a misdemeanor or a felony. And so part of any program of policing, particularly one where they are numbers driven, and let me just say that this is actually true, I think, in most places, most cities in the US, is that where mayors like low crime, and police commissioners, we all like low crime, but mayors also like communities feeling safer. And one of the mechanisms by which communities feel safer is by active policing. And one of the ways that police actively police is to look for what we call low-hanging fruit. So let's just be clear. I mean, this is not an anti-police officer discussion. Most police officers, most of them are not looking to put themselves in harm's way at all. People don't want to, they want to come home. They don't want to end up dead. So when you think about the low-hanging fruit, what happens is there's been this whole methodology around marijuana arrests, and so that they essentially harass and search and toss young African-American and Latino folks for marijuana use, which happens, and that there are all of these numbers that they have to generate in order of these marijuana arrests. They become arrests and statistics. It looks like they're policing the communities, and everybody's happy except for the young black and Latino people that are being harassed. And similar to the discussion that we had about the relationship of black and white crime, most people should know right now that the rate of marijuana use is higher across the country for white people, young folks, than it is for black people. And it is also true in New York that the rate of marijuana use is higher for white young people than it is for black young people. However, black young people are, and I don't have the statistics at my fingertip, much more likely to be stopped, to be arrested, to have marijuana confiscated, to be summoned, or things like that with respect to marijuana. So it is actually very much connected in terms of the quota piece. And again, we have to ask ourselves the question, is quota-based policing a good methodology for solving crimes? And I think there's a lot of information that says that it isn't. Is it a good methodology for partnering with communities? There's a ton of information that says that it isn't. So what we're hoping to see is maybe a little bit more subtlety and creativity around what policing models would look like, so that we just don't have a quota-driven system that ends up preying on black and brown people. Hi.
Will be hiring 200 young lawyers, $150,000 a year to do civil liberties work. But in case that rumor is wrong, what suggestions do you have, other than those wonderful jobs, for people who want to do civil liberties work? How, in an era of very tough to find jobs, lots of loans, what should they be doing? What are the strategies? And maybe this gets into how you did it too. How can they get there?
Thank you for the question. The rumor is not true, unfortunately. But I did mean to talk a little bit about my path. So here's the 2-second version on how I ended up talking to you today. I graduated from college. I worked as a paralegal for 5 years, doing racial justice and racial police misconduct work, because I wanted to figure out what a civil rights lawyer did before I jumped in. I went to Rutgers Law School, which was an outstanding school. The job market was terrible in the early 1990s. People were not hiring. I wanted to be a civil rights lawyer, actually at the Legal Defense and Educational Fund. That was my goal. 2 things. Number one, they don't have the track record of hiring people right out of Rutgers Law School. There are a lot of Harvard folks and other folks, but not so much Rutgers. There, I said it. And so I said, okay, what's my plan B? And I thought racial justice and criminal justice is really important for me, so I became a public defender. Here's the thing. Public defender job was one of the best jobs I ever had in my life. I was doing that for about five or 6 years. For those of you that are thinking about doing impact work, particularly in criminal justice, starting off doing indigent defense work is a really excellent way to, number one, get into court, because you get into court very, very, very quickly. 2, you learn how to do client interaction, which is really important. 3, investigations and being able to work with communities is critical. Understanding communities in the work is really key. And so I would very much encourage that. My next job was, I did this really strange thing. After being a public defender 5 years, I went and clerked for a federal judge, which made it the easiest job that I ever had, because I had been a lawyer for a while, but I was doing state criminal work, and I didn't know beans about the federal system. So it was a great bridge for me. I did that for 1 year. Magistrate Judge Ronald Ellis in the Southern District of New York, who was a non-traditional judge. You should look him up. I don't see anybody writing down Ronald Ellis, Southern District of New York. If you're thinking about clerkships, he's really, really good person for you to think about. I then worked at the ACLU, national office, where I did criminal and civil rights litigation. Finally, after a number of years, I got to that piece. But here's the thing that I didn't know when I started off that ended up being true when I got there, is that the work that I did was I was reforming public defender systems from a criminal justice and a racial justice perspective at the ACLU. That was my job. And so part of what made me good for that job, or the right person for that job, was the public defender work that I did beforehand. And then I was also I was a summer law student at the Center for Constitutional Rights, my second summer. For those of you that don't know, we have a program called the Ella Baker Student Program, and Brett was a illustrious member of that program, as was I in 1992. That's how I first heard of the Center for Constitutional Rights. And so the broader pieces are, number one, that the networks that you're developing now, particularly people that are thinking about social justice work, are the most important things. You will be seeing your colleagues in every job, in every manifestation of your work, so please work to build strong relations. Number two, definitely make a point of connecting with the with the treasure that you have here at Pitt, which is that there are a range of professors, including my friends on the stage here, who have dedicated their life and their work to this kind of idea, and that they are very good to know, to work as assistants with them. They also have connections to the outside broader community, and sometimes when there are jobs that are very competitive, a letter of recommendation or a phone call that comes from someone that's as well known in the field as Professor Lobel and Professor Harris makes a huge, huge difference. And then finally, just to remember that your first job doesn't define your career. It feels like it does sometimes. Like first you have to get a job, and then you want to work here, but there are no jobs, and you want to work there, there are no jobs, and then you might end up as your first job doing something that's way far away from where your path is. What I did, I quite literally did this. When I was a paralegal at Beldock, Levine, and Hoffman in New York City, I saw a resume of a young woman that had worked as a summer person at the Center for Constitutional Rights. She had worked as a summer person at the ACLU, and she had had all of these experiences, and she was maybe 3 or 4 years in, she was applying for a job. I took her resume, and I posted it on my wall, and I said, that's the thing that I want to do. I have to figure out a way to get to each one of these jobs. And I ended up getting to most of them, although not quite as directly as she did. But that kind of vision about what you want to do, that you have to make it clear in your mind, in a piece of paper, that's where I want to get. And then you have to be really flexible in terms of how you get there and essentially use your network, whatever networks you can cobble together to help you do it. Hi. I'm sorry, which case?
Nuclear scientist working in the national lab and was charged as steal some secret from the U.S. Nuclear arsenal and sold it to China, which was proved to be wrong after 7 years investigation. And the federal judge actually apologized to him, but the long investigation and the process actually was very unpleasant, to the least. And I wonder, and there was actually an array of similar cases, and it's still going on now, targeted Chinese and Asian minorities who works in the science field. And one of the recent cases working actually in NASA, who is actually just a contractor, and also being charged steal some kind of sensitive information. Most of those cases will end up settled down, but the process itself seems unfair.
Okay.
And I wonder what's your opinion about this.
Thank you very much. The question, I'm going to interpret the question as, because I know you were a lot of things, but I remember Dr. Wen-Ho Lee's case when it first began to happen, who, as you heard, was charged with stealing secrets. I have not followed those cases or any of those things, but I do have a generalized comment around the question of secrets and terrorism, which I think is connected. Some of the work that we do at the Center for Constitutional Rights, of course, is not stop and frisk, and we do a range of work around whistleblowers. We represent WikiLeaks and Julian Assange, and we also represent people who the government has accused of terrorism, a lot of whom have nothing to do with terrorism. We represent the men in Guantanamo. So here's the thing. Post 9/11, after 9/11, the world changed, and it changed most dramatically, perhaps, in the question of secrecy and terrorism. And so the paradigm has been that the government wants to continue to operate in secrecy in order to avoid the bad terrorists that we know that are out there from figuring out what we're doing. Like that's the general meme, and most people think that that's a good idea. The problem with that is that if a government acts in secrecy, then we have no ability as citizens to be able to check the government to see what they're doing, to make sure that they're doing things in a constitutional manner, in a way that's fair, which puts us in tension. People should always be in tension with their government, always, always. If you and the government agree on everything, it's probably because you're not thinking big enough. That's my view. But the tension becomes a real problem when the information that you need is being kept secret by the government, and that your attempts to get the information from the government can be seen as sort of a counterterrorism measure. And sometimes the people who are the activists that are challenging government secrecy are being cast in the media and cast as terrorists. And sometimes there are people that are legitimately stealing secrets. So the question is really, how do you begin to balance some of those things? And here's kind of where I come out, which is going back to the stop and frisk issue. We don't get anywhere on stop and frisk without the whistleblowers. I mean, we probably could have proved the case, but the case really revolved in some meaningful manner about the bravery of people that decide to push against what that blue wall of silence is and secrecy, to be able to say, here's what's happening on the other side of the wall, and it's not cool. And that is also happening in the broader context with respect to Edward Snowden, with respect to WikiLeaks, and with respect to some of those larger issues of the day. My thought on that is that in the era of secrecy, where even the things that the government is doing in our name, in our democratic name, like the spying program, like the drones program, which we're challenging, where those things are done in your name, in the name of secrecy, it is our duty as citizens to be able to unearth whatever we can so that we can evaluate. We can evaluate whether what's being done in our name is right. And frankly, you can't do that in 2014 without whistleblowers, right? It's the anniversary of Sullivan versus New York Times. I don't forget which 40 maybe? 40th anniversary, something like that. New York Times versus Sullivan. And now, but people are not walking out with big files under their arms. They're walking out with complete computer chips, and this is information that can go around the world. There's a balance that needs to be struck, but on balance, I would much rather know what the government is doing in our name that they're not telling us so that we can evaluate it, than to just to take their word that they're doing stuff that is in our benefit and that we should just sort of sit quietly and reply. Because why do I say that? Because what do we know from Guantanamo? We knew that 779 men were sent to Guantanamo in 2002, and that George Bush said that these were the worst terrorists in the world. Guess what? They weren't the worst terrorists in the world. There were some bad dudes at Guantanamo, but the government released 500 people on their own. There are 79 people that are at Guantanamo right now that the government has cleared for release that are not being released. So we know that that wasn't true. We also know that the drone program kills more civilians than it does kills targets. That's why we're challenging the drones program. Would we know that if the newspapers and the activists and the lawyers and the whistleblowers weren't making that clear? We probably wouldn't, and these things become very important.
I want to thank both Vince and David Harris for excellent presentations. The next round of classes are starting in a few minutes, so we'll end it here. Thank you very much for coming out. It's been a pleasure to have this presentation, and we hope to see you at others like this.